Assalamualaikum, my name is Dzarif Imran and today I will be talking about the ethics exercise that was given. Question 1. According to Section 103A, Subsection A of the Legal Profession Act 1976, later known as the Act, where the Disciplinary Board determined that there shall be a formal investigation. The Disciplinary Board, later known as DB, shall appoint a disciplinary committee which shall hear and investigate the matter. The rules made in the Act were to ensure fidelity in dealings with the client's money. In the case of Chung Yik Song against Majlis Peguam Negara in 2008, the appellant had breached the duty as an advocate and solicitor by withdrawing the client's money for his own private purpose. A solicitor acting as a stakeholder for two or more parties must strictly adhere to the terms of stakeholding at all times. No money or document held by a solicitor as a stakeholder shall be released or utilized by such solicitor except in accordance with the terms of stakeholding or with the express consent of all relevant parties. Although the appellant repaid back the money to the client and the partner withdraw the complaint, the act is still considered as an illegal conduct. Applying Section 103A of the Act, GD committed an offence for taking the stakeholder money. The act of taking those money for his own usage is an offence for breaching the trust. Under this section provision, the DB shall organize a disciplinary committee to investigate the matter. Similarly, in the case of Chung Yik Song, regardless that the money was paid or not, the conduct was considered as an illegal conduct. To conclude, regardless the complaint was withdrawn, the commencement of investigation can still be proceeded. This is to ensure the public trust of the legal profession is secured. Question 2. According to the Rule 7, Clause B of the Solicitor Account Rules 1990, later known as the Rules, is a provision that revolves around trust money. Subclause A, Clause 5, provides that the client's money can be used for certain purposes. In the case of Selvaratnam anak lelaki Velopilai against Jayabalan Karupiah in 2009, the appellant used the client's money to pay the legal bill. After the client realized of the appellant's misconduct, the client filed a complaint to the Bar Council. The DB commenced an investigation and the appellant was found guilty of misconduct. The President of Justice, Judge Tunzaki, held that the money remained in trust, regardless that the amount is sufficient to be utilized to settle the legal fee, and the DB did not commit a mistake against the appellant. Applying the law in this issue, Judy's conduct amounts to professional misconduct. As a solicitor with 20 years of experience, the decision of using trust money must not be overlooked. Judy should not take the client's money for his own usage. The core principle of legal ethical rules is honesty and integrity. The fundamental aim of the legal ethics is to maintain honor and dignity of the legal profession, to ensure the spirit of friendly cooperation, honorable and fair dealing of the counsel with his clients. By virtue of Section 94, Clause 4 of the Act, where the solicitor is found guilty for the honesty of any money of a client, and the Bar Council consider the interest of the client, the Bar Council may apply to the DB to suspend the solicitor from practicing further notice. To conclude, it is unethical for a solicitor to use trust money for their own gain. It is a breach of trust between the client and the solicitor. Judy might be held liable under Section 100 of the Act, which is suspension not exceeding 5 years, a fine, or striking off the role. That will be all for my presentation for today. Thank you all for watching and have a good day. Thank you.